Welcome to the 46th lecture in this lecture series on international investment law. We discussed the typical dispute resolution provisions of an international investment treaty in the last lecture. We discussed the recent trends in dispute resolution provisions with special reference to the Brazil-India BIT of 2020 in this lecture. Part 4 of the BIT of Brazil and India deal with institutional governance, dispute prevention, and settlement. Thus, the focus here seems to be threefold. 1. Set up institutional governance mechanisms to address investor grievances. 2. Prevent disputes. And 3. Settle disputes if they nevertheless arise. Articles 13 to 17 predominantly concern institutional governance mechanisms. Article 18 deals with the second objective of preventing disputes, and Article 19 addresses dispute settlement, which is the third objective. Article 13 of the BIT is titled Joint Committee for the Administration of the Treaty. It consists of representatives of both parties, and its objectives are to supervise the implementation and execution of the treaty, discuss and make known opportunities for the expansion of mutual investment, coordinate the implementation of the mutually agreed cooperation and facilitation agendas, consult with investors and relevant stakeholders when applicable on their views on specific issues relating to the work of the joint committee, discuss issues and seek to resolve disputes concerning investments of investors of a party in an amicable manner, and lastly, supplement the rules of the arbitral dispute settlement between the parties. Article 14 obligates each party to establish a national focal point or ombudsman. Purpose of the ombudsman would be to support investors from the other party. In the Indian context, the treaty provides for establishment within the Department of Economic Affairs, Ministry of Finance, the Ombudsman. Responsibilities of the Ombudsman would be to endeavor to follow the recommendations of the Joint Committee and interact with the national focal point or Ombudsman of the other party in accordance with the treaty. Follow up on requests and inquiries of the other party or of investors of the other party with the competent authorities, including the state and the local levels, and inform them on the results of the actions. Assess, in consultation with relevant government authorities, suggestions to improve the investment environment and complaints received from the other party or investors of the other party. Address differences in investment matters in collaboration with government authorities and relevant investors with a view to helping in the prevention of disputes. Provide timely and useful information on regulatory issues on general investment or on specific projects to the extent possible. And lastly, report its activities and actions to the Joint Committee when appropriate. Ombudsman of each party is obligated to cooperate with its counterpart and the Joint Committee to prevent disputes. Article 15 of the BIT provides for exchange of information, while Article 16 obligates each party to respect protected information. Article 17 obligates each party to disseminate general information relating to investments, regulatory frameworks, etc. to its investors. Now we come to the core aspects of the dispute resolution mechanism in the Brazil-India BIT. Article 18, titled Dispute Prevention Procedure, states in Article 18.1 that if a party considers that a specific measure adopted by the other party constitutes a breach of this treaty, it may invoke this article to initiate a dispute prevention procedure within the Joint Committee. So therefore, the first step is to initiate dispute prevention procedure, which is to be conducted under the aegis of the Joint Committee. Two important aspects are to be noted here. First, the dispute prevention procedure is invoked by the party to the BIT and not an investor. And two, the provision is invoked to initiate the procedure within the Joint Committee. Therefore, it is not by arbitration. The invocation would be through a written notice identifying the specific measure in question, informing findings of fact and law underlying the submission, and if the measure pertains to an investor, initial submission is to identify the specific investor. The joint committee is supposed to meet within 90 days from the date of the request, and the committee shall have about 120 days from the date of the first meeting to evaluate the submission presented and prepare a report. Where the measure pertains to a specific investor, the representative of the affected investor may be allowed to appear before the joint committee. In discharging its functions, the joint committee may also invite other stakeholders to appear before the committee and present its views. The report that is to be presented by the joint committee should identify the submitted party, describe the measure in question and the alleged breach of the treaty, and the findings of the joint committee. If the dispute is not resolved on the completion of the time limits provided in Article 18, or if one of the parties does not cooperate, then the dispute can be referred to an ad hoc arbitral tribunal or other arbitral tribunal prescribed in Article 19. Article 19 of the treaty deals with arbitration between the parties to the BIT and not between the investor and the host state. In case a dispute remains unresolved, it would be referred to an ad hoc arbitral tribunal where the parties would be the two states which are the parties to the BIT, that is Brazil and India. But parties may, instead of constituting an ad hoc committee or an arbitral tribunal, can also agree that the dispute may be referred to institutional arbitration. Article 19.2 is an important provision which states the purpose of the arbitration is to decide on the interpretation of this treaty or the observance by a party of the terms of this treaty. For greater certainty, the arbitral tribunal shall not award compensation. So, the concept of compensation itself is eliminated. What is to be decided by the tribunal is on the interpretation of the treaty or on whether a party has observed the terms of this treaty or not. The tribunal is also to make determination regarding the following provisions of the BIT, that is Part 1, which contains scope and definitions. Part 2, which contains general obligations of the parties, including national treatment, protection against abusive treatment, direct expropriation, etc. Article 16, treatment of protected information. Article 21, prudential measures. And Part 7, that is final provisions, which includes relationship with other treaties, amendments, etc. In addition, the relevant provisions of Article 9 specifically exclude determination by the arbitral tribunal of the following provisions, that is Article 8 on transparency and Article 10.1, which deal with measures to prevent and fight corruption, money laundering and terrorism financing as a part of host states' laws and regulations. The tribunal is to be constituted within 4 months from the written request. If there is a default or inability in constituting the tribunal, either party may invite the President of the International Court of Justice to make the necessary appointment. Article 19.6 requires the arbitral tribunal to have the experience or expertise in public international law or international investment rules or international trade or the resolution of disputes arising in relation to international investment agreements. Be independent of and not be affiliated directly or indirectly with any of the parties or with the other arbitrators or potential witnesses, nor take instructions from the parties, and comply with the code of conduct detailed in Annex 2 or any other standard of conduct established by the joint committee. Brazil-India BIT contains Annex 2, which lays down the code of conduct for arbitrators. This code of conduct basically covers the procedures relating to independence and impartiality of arbitrators and their challenge. The tribunal is allowed to arrive at a decision by a majority of its members, and such decision would be final and binding on the parties, who are to comply with it without any delay and in accordance with its laws. The tribunal is empowered to determine all questions relating to its competence and its own procedure, taking into account the PCA, that is Permanent Court of Arbitration's optional rules. The costs of arbitration are to be equally shared between the parties, and each party is to bear its own costs of representation. The tribunal nevertheless can allocate costs in its arbitral award. This concludes our 46th lecture in the lecture series on international investment law. We will look at a few more facets of dispute resolution in international investment law in the next lecture. Bye bye and stay safe.